doing this.
Yes. So, and how many were on your team on the brief?
So it was Willie and me
So,
from Goodwin.
and I'm not
we
representing
had,
each side.
3 people
But there are
from
3
the lower
district
court
courts.
council.
Okay.
That did this for us.
All right.
Total.
Wow.
I think that's great.
So, do I have a name?
You're over
tag
here,
or something?
right here.
Okay, right in the center of it. Okay. I take this as a souvenir.
You can,
So-
actually. Oh, Gidget, can I have one? Oops.
I should have
I
some
need-
Bio here to flavor the That's right. What, like a liquid water enhancer?
All right, so the webcast is about to start, so let's roll.
Okay. So what is the format? Just remind me.
I'm gonna set up the case.
Okay.
And then, I'm gonna invite you to tell us about.
Shuffling us into
First,
the
we'll
room.
do the
Yeah.
merits essentially, and then we'll talk about the argument
Okay.
as a second round.
All right, that's
Like
the
him
merits
right
and
here.
then the argument. The merits of the issue in the
Fine,
Supreme
I'm
Court.
around
Yes,
that.
Yes, okay.
and sort of explaining.
Sure.
All right. Good afternoon, everyone, and welcome back to the Supreme Court series here at American University Washington College of Law. My name is Michael Carroll. I'm the director of the Program on Information Justice and Intellectual Property, and we have a distinguished set of speakers here with us, including Mr. Dabney next to me, who is down at the Supreme Court arguing earlier this morning. So thank you very much for making the time to join us.
Happy to do it.
And I am going to bring your illustrious bios up on my iPhone as we speak. Oops, sorry. So Jonas has them. Well, my colleague Jonas Anderson, you want to introduce our speakers?
You can now that you have.
I got it. All right. So James Dabney is the co-head of the Hughes, Hubbard & Reed's Intellectual Property and Technology practice. He specializes in contentious matters involving patents and other forms of intellectual property and a variety of technical fields. He's also an adjunct professor at Cornell, where he teaches a course entitled Conflicts in Patent Law and Practice. Next to him is Brian Burgess, from a partner in the Goodwin Proctor Litigation Department and Appellate Litigation Practice. His work is primarily appellate matters in complex civil litigation in federal courts, and he has experience in a wide range of areas, including constitutional law, administrative law, patent law, antitrust, and financial services litigation. And he clerked for Justice Sotomayor when she was on the Supreme Court, and prior to that, he had clerked on the Seventh Circuit. To his left is our good friend and colleague, Professor Megan LaBelle at the Catholic University of America, where she teaches and researches in the area of intellectual property and civil procedure. And this is a case about civil procedure and patent law. So tailor-made for Professor LaBelle's interests. Prior to joining the academy, she had worked for a number of years as a commercial litigator in the Los Angeles firm of Munger, Tolles, and Olson, in which her practice was an intellectual property practice. And next to her is my good friend and colleague, Professor Jonas Anderson, who is our patent law specialist on the faculty here at American University. And he, prior to joining our faculty, he spent a year working at the Berkeley Law School as a fellow. And prior to that, he clerked for Judge Alan Lurie of the U.S. Court of Appeals for the Federal Circuit. And he practiced in California as well at Latham and Watkins. Okay, so this is a case that involves sort of civil procedure as the source of law and patent policy as one of the reasons we have this case. For those of you in the room, you will see on the screens at the top, I hope, a statute that appears to answer the question. Any civil action for patent infringement may be brought in the judicial district where the defendant resides or where the defendant has committed acts of infringement and has a regular and established place of business. a fairly restrictive scope for where the plaintiff may bring the claim. However, a more general statute, Section 28 U.S.C. Section 1391, since 2011 has read that except as otherwise provided by law, and we'll come back to that, this section shall govern the venue, meaning the place where the lawsuit can be brought. In analyzing that, an entity with the capacity to sue and be sued in its common name, corporations and other forms of sort of artificial legal entities, shall be deemed to reside in anywhere where the court has personal jurisdiction. And for those of you who've been through constitutional law and civil procedure, you now know that that's based on the specific personal jurisdiction is based on the level of activity that the defendant has had with the forum state. So in general, in patent law, if you're making goods or services that are available throughout the United States, the chances are that the personal jurisdiction test is fairly easy to meet. Why? So what? All my first-year students in the room know that my favorite lawyer question is, so what? Who cares? Well, a lot of people care, and they care for a variety of reasons, but in particular, there's a lot of money at stake. If you look at the map of the United States and you look at the judicial districts in which patent litigation cases have been brought, you see that you get hundreds collected in a few districts where there are local rules that are specialized for patent litigation. And then the Eastern District of Texas, and in particular the Marshall, Texas courthouse, receives a substantially larger amount of the litigation. Why is that? Because those rules tend to favor plaintiffs in a variety of ways that I expect we'll hear about more. And therefore, they attract a lot of patent litigation. And each one of those cases is worth significant sums of money, 10 to hundreds of millions of dollars. So you start to do the math, and it's pretty quickly apparent that there are billions of dollars theoretically at stake if we were to reallocate where these disputes would be brought. And there would be some shift in the outcomes, say the parties and the litigants, and we're going to hear more about that. But the legal question really turns on the meaning of this word resides in section 1400B. Is that a word that should be read according to prior Supreme Court precedent, which would limit where a corporate defendant or an entity defendant is deemed to reside? Or should the word resides be informed and supplemented by the definition of residence in section 1391C2? And one has to read the otherwise provided by law to suggest that it would still be complementary and not contradictory to rely on 1391. So in crux, that's the statutory interpretation question. Those are the stakes, and now we're off to the races. So, Mr. Dabney, you presented your position before the court. How about sharing it with us a little bit more?
Well, I think to understand this case, you have to know that the parties to it are business competitors that are based in the Midwest. The plaintiff is headquartered in Northfield, Illinois, and the defendant is headquartered in Carmel, Indiana. And the lawsuit was brought in the District of Delaware, where there was no relevant development activity undertaken on either side. The patented subject matter was developed elsewhere. The accused subject matter was developed elsewhere. Nothing attracted the plaintiff to Delaware in terms of what the case was about. Because the defendant was a relatively young company based in Indiana that had done everything right, it had developed its own product, had its own brands, had its own patents, had its own process, had its minding its own business. It had no footprint in Delaware. It had no contracts in Delaware. It had no licensure in Delaware. I mean, Delaware was as far into it as Alaska. When the lawsuit was brought in Delaware, it presented a case in which someone who teaches a course entitled Conflicts in Patent Law and Practice might have had the fortitude to make a motion that basically says the emperor has no clothes, and that the Supreme Court's interpretation of Section 1400B actually is still the law. I say fortitude because in 1990, the Federal Circuit took the view that the Supreme Court's interpretation of this statute that you have on your screen was no longer valid precedent, and that they were going to interpret the statute differently than the Supreme Court had. And by and large, between 1990 and 2014, when we were called to do this, the lower courts, so far as we know, they had to follow the Federal Circuit's authority, and they did. I'm not aware of any efforts to try to seek overturning of the Federal Circuit's precedent until our case. So when we did that, we basically took the position that the reasoning of the Supreme Court's case interpreting 1400B remains valid, that the Federal Circuit's rejection of the Supreme Court's interpretation of the statute was in excess of authority, and we preserved the issue for Supreme Court review, but in the trial court we were saying that venue was improper also because there also was no personal jurisdiction over Heartland, which was the only seeming way out of venue under Federal Circuit precedent at the time. The district court, of course, denied the motion. A petition for writ of mandamus was taken to the Federal Circuit for review, which is the standard appellate process for seeking immediate review of a venue ruling. I should say that, at least in New York, if you don't at least make an attempt to seek review of an adverse venue ruling, you run the risk of waiving your venue defense if you continue with discovery and trial procedures. It's a risky strategy to just say, well, I'll try to get appellate review after trial. And the Federal Circuit in April of 2016 dealt with the issue in rather brief fashion. They took the view that their precedent was valid, and they'd settled this question 25 years ago, and that's their story, and they're sticking to it. And they did not seem to see any merit at all. In fact, the Federal Circuit used rather harsh language in its opinion about the arguments that and this is what I say, it takes a certain amount of fortitude to do this type of thing, because courts often don't mince words when you make arguments that challenge their precedent. And then we petitioned the Supreme Court to review this interlocutory order, and the court granted cert in December, and the question in the case basically was framed exactly as the court had interpreted the law in 1957. Does 1400B still constitute the sole and exclusive provision controlling venue in patent cases, and is not to be supplemented by that other general venue statute, 1391? And that case came before argument this morning, and I don't know how much you want me to say further about it.
We'll come back into the argument.
That's how we got to where we are, and Professor Carroll accurately characterized what the statutory issues are. But that's the backstory, how we got to the Supreme Court.
Okay.
And the case is set for trial in October.
Right. And just so we're clear that I mean, what we have is sort of two versions of a position that the question that the court's considering has been asked and answered. And your say the question was answered in 1957.
Correct.
Okay. Mr. Burgess, you'd take a different view, that there's a different source of an answer. Tell us about that.
We think Congress supplied the answer when it passed a statute that defined the meaning of residence
Oops. Sorry about that. Go ahead.
for all venue purposes. In our view, the case turns on a pretty simple textual syllogism. No one doubts that the patent venue rule applies. There are many specialized venue statutes that apply in different situations. This is a patent infringement case, so 1400B is the provision that determines the venue rule. So you look and see, well, what supplies venue under 1400B? One situation is if it's a principal place of business and infringement. Another is if the defendant resides there. 1400B does not define resides. Where would we look to find that? In a general provision, 1391C, that defines residence for all venue purposes, runs through comprehensively the meaning of residence for corporations, corporate defendants, corporate plaintiffs, LLCs, or various unincorporated associations, individuals. So we think that is clearly defining what it means, what residence is for venue purposes. If you had any doubt whether 1400B is a venue statute, whether this would qualify as a venue purpose or whether it's accepted for some reason, Congress also took the trouble in 2011 to define venue. In 1390A, we have a clear definition of venue, which no one, I don't think, disputes, encompasses 1400B. There are some exclusions in 1390 for admiralty cases, for example, but they didn't exclude patent cases. And so I really don't think there's any doubt that if this text were presented without the historical gloss of Forco, that this would be a super easy case. The text the whole thing, there is a term that is undefined in the provision, and then we have a definitional section that supplies the definition. So the question is, because the fact that the Supreme Court interpreted an earlier version of the statute in the 1950s in Forco, does that change the result somehow? Did the court say that for going forward, under even notwithstanding revisions to the statute, the 1391 can never apply to 1400? That it is an island of itself, regardless of the ways in which Congress sort of deals with it. And then there's also the issue, which came up in argument, we can sort of get in more into the merits of whether the except as otherwise by law clause does significant work. One thing we would note in that, there's a few different versions of the statute that's sort of worth keeping track of. There's the version that was in place at the time of Forco. Then the statute was amended in 1988, and then that was the provision that was before the Federal Circuit in the V.E. Holdings case in 1990. Interestingly, the except as otherwise by law language was not in 1391C at that point, so I'm not sure if you think that is doing the work. Maybe you think V.E. Holdings was right and then things went the other way, which is sort of an interesting view. But at that point, Congress changed the law from what it had been, the statute, what it had been at the time of Forco, to make clear that the definition of residence should be anything within this chapter. And the venue statute is something that is included in the relevant chapter. Congress then, in 2011, enacted something called the Venue Clarification Act, which you might think was designed to clarify venue and provide sort of a comprehensive definition that would sort of be cross-cutting. And it was a project that was sort of a decade in the making, working with the American Law Institute and the Federal Judiciary Conference, that was focused not specifically on patent venue necessarily, but wanted to resolve several questions that had sort of troubled the lower courts that they had divided on about what is the residence for individuals? How do we deal with unincorporated associations? What about aliens? Do we want to continue to have a rule that they are entitled to no venue privilege, or do we want to adjust that such that it'll turn on residency rather than pure alienage? And what they did was they adopted a cross-cutting definition in 1391C that we believe, by its clear terms, applies to all venue statutes, not all venue statutes except for the patent venue statute. That's not the statute they wrote. So the question is, was Congress obliged to do more than that because Forco existed? Were they required to like pat their tummy and pat their head saying we actually want to change the law and we think no, that the court, when Congress amends law and changes language, the court's precedent provides that we're going to look at that language on its own and give it its clear meaning. We don't require a special clear statement anytime that Congress wants to deviate from our prior interpretation of an earlier statute. So that's, in a nutshell, that's sort of our general approach to the issue. And one thing I'll say sort of in the initial framing, it's sort of interesting talking about it being strange to sue in Delaware, but the general rule in civil litigation, and this is something Professor LaBelle has written about, is that corporations are subject to venue wherever they're subject to personal jurisdiction. So this is a case sort of unusually where the argument is that the Federal Circuit erred by not treating patent law differently, by sort of harmonizing it with the general rules for civil procedure. That was the problem. And it's sort of ironic given that often the critique of the Federal Circuit is that it's trying to make patent law a body of its own that is not harmonized with the general law. Whereas here, the definition, our understanding of what Congress did brings patent law more into keeping with how venue is applied for corporations, for unincorporated associations across the board.
All right, I'm going to turn it over to you guys, but just so we're keeping score, right, there's always been a version of a patent venue statute for a very long time. There's been a general venue statute. An earlier version interpreted by the Supreme Court in 1957 holds that the prior version of 1400B is the exclusive source of jurisdiction in a patent case. 1988 comes along, Congress changes 1391. The Federal Circuit treats that change as being a meaningful change in the law, and its VE Holdings says from now on, residence is defined by personal jurisdiction. Then we get the 2011 amendment, which is the text you see now, and the Federal Circuit said in the lower court in this case, we're sticking with our interpretation from the VE Holdings. And on review is the question of whether the 1957 Supreme Court precedent is the source of, is still the law because 1400B stays as a separate revision, or whether one or both of these revisions by Congress changed the law. That's what's up for grabs. So Professor LaBelle, help us bring the lens back a little bit more. Try to situate this within the broader sort of framework of civil litigation and venue provisions.
Sure. So, are these on?
Yeah.
They're on. Okay. So, as has been mentioned already, I mean, the Supreme Court often criticizes the Federal Circuit for treating patent cases exceptionally and for creating special rules for patent cases. But the argument that I have made and that others have made is that this is not the case here. This is one case where the Federal Circuit is actually treating patent cases just like other federal civil litigation. So all you students in the room, I am sure, have taken civil procedure. You've all studied venue and you've studied 1391C, right? 28 U.S.C. Section 1391C, and you know that venue is proper where under 1391B, that's the general venue statute we've all been talking about, venue is proper where a defendant resides, if all defendants reside in the same state. I'm summarizing, but something to that effect. But then the question is, okay, well, where does a corporation reside, right? Or where does not just corporations now, but other unincorporated associations. And then you look to 1391C, which defines where corporations and other entities reside. And they reside in districts where the defendant is subject to personal jurisdiction for this lawsuit. So that doesn't mean anywhere the defendant is subject to personal jurisdiction, but it's personal jurisdiction for this lawsuit. So, so in this case, in Forco, one thing that I don't think has been mentioned specifically yet that I would like to make sure we talk about is when the Supreme Court interpreted 1391C in Forco, so that was in 1957, and they were interpreting the 1948 version of 1391C, it looked very different than it does now, because at the time, 1391C was not just, it didn't just provide a definition of residence like it does now. Instead, it also was a substantive provision. So in other words, it set out where venue was proper for corporations and provided a definition for residents. So at the time, the Supreme Court decided Forco, it was sort of faced with these two conflicting venue provisions. You had the specialized venue provision in 1400B, and then you had this generalized provision in 1391C. But in 1988, Congress changed that. So first Congress changed it and made 1391C purely definitional, and I think this is very important. And I urge anyone who's interested in this case to actually go and read the V.E. Holdings case, because the Federal Circuit, in my opinion, did a very careful job in that case, considering Forco, considering the language of the previous statute, considering the language of the 1988 amendments, and took note that Congress changed 1391C, and you no longer had this conflict between a specialized venue statute and the generalized venue statute. Instead, you now had a specialized venue statute in 1400B, and everyone agrees that that applies in patent infringement actions, and then you had a definition that was provided in 1391C. So from, I guess, to get back to the initial question, just about looking at this from sort of in the bigger picture of civil litigation, venue in patent cases is no different than venue in all other federal civil litigation. Corporations can be sued where they are subject to personal jurisdiction, and Congress made this choice. And made this choice that essentially where corporations are operating, where they have sufficient minimum contacts, they should be they are subject to personal jurisdiction, and therefore venue is proper. There's no indication that Congress intended to treat patent cases differently, right? Why should, I guess my question is, why should corporations in patent suits be protected more than corporations in other types of suits? That doesn't mean that what's going on in the Eastern District of Texas is okay, but in my opinion, it's a problem to be addressed by Congress or through other avenues, because it's, as Mr. Jay said in an argument today, it's not a venue problem that people are really complaining about in terms of what's happening in East Texas, but instead the procedures that are used in East Texas, some of the results in East Texas, some of the practices that, in my opinion, have nothing to do with venue.
Great. And I forgot to disclose, so Professor LaBelle is on a professor's brief that's favoring the respondent. Professor Anderson and I both signed an amicus brief that favors petitioner. I'm here as the neutral moderator, so forget the fact that I signed that brief, but Professor Anderson doesn't. So it's interesting that this is a suit between two operating companies where the venue that was chosen was the District of Delaware, which is considered a relatively non-controversial site for patent litigation. But we keep hearing about Marshall in the Eastern District of Texas, and Professor Anderson, you've written about, both professors have written on this topic. This is deeply interesting to both of them. So Professor Anderson, maybe switch us now to the patent policy stakes that are going on. Why are there so many friends of the court trying to be friendly, pull them to one side? Why do they care so much about Marshall, Texas?
Yeah, so I'll do that. Let me start with an anecdote at the court today. So I was in the Supreme Court bar, which sits in front of the bar and sits right behind the litigants. And after the argument was over, behind me, Daryl Issa was in the audience. for those of you that don't know, he's a representative from California. He's the subcommittee chair for IP of the Judiciary Committee. And so he was there because he has an interest in this case. It's not really, he doesn't care about 1,400, or he might.
He's a patent owner, right?
Yeah, he got like 50 patents, I think. So he might actually care about that. But I think he cares more about the thing Mike referred to, which is the Eastern District of Texas phenomenon. And so there's been such a growth in the Eastern District of Texas that patent owners go to Eastern District above and beyond all other courts. And there are a number of reasons for that. Part of the venue expansion in the AIA increases that number so it looks bigger than it really is. But what can't be denied is that Texas is extremely popular with plaintiffs. And so my position, which is different than Megan's, I don't really care about the civil procedure as much as the patent policy. And as a patent policy matter, I think having a third of cases basically tried before one judge, Judge Rodney Gilstrap of Texas, is not good for patent policy. And so we can debate about whether it's Congress's job or whether the courts can fix this. I'm kind of ambivalent to who does it. I really think that someone needs to do it, though, because we've had a number of years where Texas has grown and grown as a destination for patent plaintiffs. And that's, I think, for reasons that aren't good for the patent system. The reason plaintiffs like Texas is because they get a lot of procedural advantages in Texas. They get to choose their judge, essentially, and a number of other things that plaintiffs like a lot. And so I think that can be solved. One way is by reducing the venue choices that plaintiffs have in patent cases. So I think I'll stop there, and we can continue the discussion.
And we should note that Congress has considered a bill that would have essentially addressed this through legislation, whether that's here or there. But speaking of the court, I'm looking at the transcript, which came out later than usual, so I haven't had a chance to read the entire thing. But you'll notice that Mr. Dabney gets a paragraph and a half out before the first question is in. So that's a fairly hot bench when you haven't even gotten to introduce.
That's more than you usually get.
So what were your impressions of the way the justices were looking at the case, and how do you feel like the discussion went?
Well, it was, some of the justices, by their questions, seem to be asking questions you'd like to hear them ask. The way that the petitioner framed the issue is one that the court basically was faced with the choice of deciding whether to uphold or to destroy the venue protection that the Congress had prescribed in 1400B and the court's interpretation had declared. And framed that way, it's a matter of stability of the court's own precedent and what must Congress do if what it intends to do is to abrogate a long settled precedent, construing a statutory text that has not changed at all. So my feeling listening to the argument is that there are quite a number of justices who are concerned that their precedent has not been given adequate respect. And I think Chief Justice Roberts is especially concerned about, I think he was the one who mentioned a quarter of the cases of patent cases are on the docket of a single judge. And I think that statistic, by the way, shows that I obviously don't agree with Professor LaBelle on this. I think that patent cases, the claims for patent infringement have characteristics which require a law like 1400B. It's really not, I think, an accident that there is a special venue statute for patent cases, and there is no such statute for train wreck cases. It is a fact that, as experience has shown, that claims for alleged patent infringement lend themselves to the type of asportation, shall we say. They can move around and be bought and sold and packaged and used to support rent-seeking behavior that really is unique in that it is completely detached from any physical reality. That there's no tangible loss. The claim doesn't have to be where anybody actually is, and in fact, patent litigation is almost unique in that until you get to the end of the case, you don't know whether there was any injury at all, because there might not have been infringement, or the patent might be valid, and there might be no obligation to pay anything. So what a claim for alleged patent infringement allows a plaintiff to do is to expose a defendant to the prospect of paying hundreds of thousands, if not millions of dollars, in order to prove that it doesn't owe anything. So I was the most surprising part of the argument for me was when, on his own, Justice Breyer voiced the view that he sees all this talk about suits in Texas, and what is that to me? He seemed to think that the geographic distribution of patent litigation in the United States was something that did not really bear on the issue before the court, and the response that I gave to that was what that shows is the importance of enforcing 1400B, because everyone agrees that whatever may be the actual motives for patent plaintiffs to concentrate in this district or that district, at least for relatively small and medium-sized businesses like Heartland is, they couldn't do it if they had to adhere to the law of venue that the Supreme Court held in Forco. So those are just some impressions.
Okay, and Mr. Burgess?
Sure. I mean, off the bat, there's one thing we'll agree about. That was an unusual question from Justice Breyer, an unusual approach. He's usually someone that is quite interested in the practical policy implications, and he sort of said, let's take that off the table. I want to focus on what the statute actually says. Yeah. So that was interesting. I think it tends to be a dangerous game to try to engage in tea leaf reading. And so I mostly won't do it. We had another case argued earlier this term involving copyright of designs on cheerleading uniforms for varsity brands, and we were convinced that the chief was against us. Everything he said was against our position. Sometimes he'll ask hard questions to both sides, but he just killed us. And then he voted with us this past week. So I think it's very difficult to tell. But there were a few things that I found interesting. One was the Justice Breyer approach. Another, I think, sort of consistent with what Professor LaBelle was talking about. Justice Ginsburg had a lot. She is sort of a civil procedure person and comes from that background, and I think that showed. She had a lot of questions about why is patent venue different? Can you come up with any other sorts of statutes where venue is restricted in this way, that residence has this sort of narrow meaning? So we thought that was interesting. I don't think it necessarily forecasts her vote, but it showed the sort of angle that she was coming at it from a civil procedure perspective rather than a patent law perspective. Another sort of thing that we found useful was sort of the way in which the 2011 Act, in our view, was very helpful because it clarified a lot of outstanding questions in the law, such as how to deal with unincorporated associations, which TC Heartland is. Forco involved a corporation up until that point. LLCs are a fairly new invention in the law. They only sort of came into being in their modern form in the 1970s. So the question of how do we say that a 1950 Supreme Court decision interpreting an 1897 statute provided about how to handle LLCs. Petitioner has answers to it, so I don't want to suggest they didn't, but we thought it is useful that our position is, well, Congress answered that, and rather than sort of engaging in those sort of difficult inquiries about figuring out what the common law means about LLCs, you can just supply the definition that Congress created. And so a few justices were sort of interested in that question, I thought. And a few were totally quiet, so we have no idea what Justice Alito thinks about this case. He was very interested in how ERISA applies to church plans in the case before us, and had nothing to say about patent venue. So, and Justice Thomas was silent as usual. So who knows? But
And I'm just before we let Professor LaBelle in, I mean, Justice Kennedy has been the most worried about the patent trolls, the patent assertion entities. So one would have expected that to be on his mind. But did he engage?
I mean, he asked the question of, seems like there are, arguments have been made that there are significant jury verdicts in the Eastern District of Texas, and this is what it's attracting patent plaintiffs. Is that relevant? How should I think about that?
He was questioning whether he should even care about Eastern District of Texas, because this was about Delaware.
Right.
And so
this is about Delaware, and I'm interpreting a statute. So, to what extent are those sort of considerations germane? He asked that, but there weren't, in comparison to, I think, a lot of other. And maybe it's because it's a procedural case rather than about substantive patent law. There was less of that sort of concern about trolls from the bench than I've seen in recent cases.
Interesting. And Professor LaBelle, what do you think?
Well, I was at the argument this morning, and it was the quietest argument I've ever been to. So I was surprised at how few questions there were. Again, I don't want to make predictions about justices, but I thought, okay, you can make the predictions. I thought that the Chief Justice asked Kraft some of the hardest questions and seemed most concerned about the policy more than any of the other justices, in my opinion. I think, I also think the argument at the end, Mr. J, Kraft's counsel, made a point about the potential impact on other types of cases, Hatch-Waxman cases in particular, and what the fallout might be. And that seemed to get the justice's attention. I think Justice Sotomayor asked a follow-up question about Hatch-Waxman cases and how a decision like this might impact venue and other types of cases. And that is something I hope that the justices will think about. And that's something that I've been hearing a lot of from the proceduralists. How might this impact admiralty cases? How might this impact other types of cases with special venue provisions where courts have read 1391C's definition into those specialized venue provisions? Does that mean, would T.C. Heartland wipe out all of those decisions, and now courts have to figure out what resides means in all those specialized venue provisions? So I agree about Justice Ginsburg. She seemed to focus on the procedural aspects. And then Justice Kagan asked Mr. Dabney an interesting question at the beginning, I thought, about basically how explicit does Congress have to be to overrule our decision in Forco. I think Professor Anderson and I may take a different view on Justice Kagan here. I thought her question seemed, she was asking some probing questions, and I think maybe she's still on the fence, but Jonas may have a different view there.
I want to ask your opinion about that. And for the students, to me, this is a fascinating, all the different versions of statutory interpretation arguments get made in this context because of the dialogue between the courts and the Congress. And one of the general principles is that if Congress is aware of court precedent interpreting a statute, and they then change the statute, it is thought that they're doing it with the court precedent in mind. But the problem is, which court precedent? Is it the Supreme Court Forco case, or is it the Federal Circuit's V.E. Holdings case? And Justice Kagan frames her question by saying, basically, well, the Federal Circuit basically ignored us for 30 years, so isn't it fair to say in 2011 that the Congress was essentially listening to the Federal Circuit's ignoring of our precedent? And that was her framing of the way to think about this dialogue. So is she saying that VE Holdings actually was, ignoring our precedent, but so what? We got to be practical about.
So we'd had a conversation about this beforehand, and I went back to read it, and that is what she said. I'm not sure that's what she meant. I mean, or if she meant if the Federal Circuit was ignoring our precedent, should we assume that Congress is then legislating against the backdrop of VE Holdings? I also thought Justice Breyer asked a question on that I thought was important about. What if anything did Congress say in 2011 when it amended 1391 about VE Holding? And the ALI work is very clear that the ALI work, which was the basis for the amendments in 2011, the ALI report makes very clear that they approved of, there was an approval of what the Federal Circuit did in VE Holdings and said, I think the word was a partial palliative, that sort of VE Holdings is helping the problem. It wasn't that the Federal Circuit, was just ignoring, the Supreme Court's decision in Forco. And Justice Breyer, I watched his reaction to that response, and he did seem to sort of nod his head and think that was a helpful response. So, but I don't know how to interpret Justice Kagan's question. She did say that. Whether she meant it, I don't know.
Right. And Professor Anderson, what do you think?
It was really interesting today because there were a lot of heavy statutory arguments, but on the side there was a lot of policy arguments about a court that's not even involved in this case. And so the one way to think about this case is the more they were focused on the Eastern District of Texas, the more it favors the petitioner. And the more they're focused on the civil procedure, the statute in the case, the more it favors respondent. And so if you go by that, which is my theory, Justice Kagan and Justice Roberts, I think, were the most interested in Texas. They asked the most questions about Texas or Forco. They gave you the impression that they were kind of for petitioner. Again, it's hard to read into this. And then on the other side, I was surprised by Justice Breyer and Justice Kennedy were not interested in Texas at all. And so that kind of cuts both ways and says that, well, if they're interested in what's actually going on with the statute, not in Texas, then we might get a different case than if it comes out the other way. There were a lot of silent justices, Justice Alito, Justice Thomas, Justice Kennedy didn't ask many questions. Justice Breyer was actually pretty, for him. And Justice Sotomayor was asked questions at the start and at the end, but in the middle she was largely silent. So it's tough to read this case more than most, I think. I think the more that East Texas influences the justices, they want to take some bite at Eastern Texas, but I think this is a weird case for doing that. And so I'm not sure they're going to take the invitation to take a bite at Texas here.
Interesting. Let me offer the chance for people in the audience to ask our panelists questions if they have any.
Where is this TC Heartland LLC incorporated?
Indiana.
What contacts to Delaware do you have?
None.
Well, they distribute their infringing products in the state of Delaware.
The Washington Legal Foundation filed an amicus curiae brief because they felt that this case was on the absolute outer bounds of the Supreme Court's recent personal jurisdiction precedent. The situation is that one of Heartland's customers is a big national retailer that has stores all over the country. And the contract is between Heartland and Indiana and this big customer out in the middle of the country. And the company issues purchase orders from time to time with shipping instructions. And so, Heartland will make up product in Indianapolis and drop ship it per the customer's instruction to destinations. Sometimes the shipping destination is in Delaware, but it's the shipments into Delaware are by common carrier, and the buyer even pays the freight in some cases. And so if you're if traditional notions of fair play and substantial justice, whatever that means, that is contended by some to be a more administrable standard than regular and established place of business. Traditional notions of fair play and substantial justice. Reasonable minds could say that fulfilling a purchase order in those circumstances it does not comport with the traditional notions of fair play and substantial justice, that they should have to answer a nationwide patent suit in Delaware.
But what if you made the argument that, say, you take a company like Amazon
Yeah,
that ships everywhere?
yeah.
So if you're not subject to venue in Delaware because you ship into Delaware, where would Amazon be subject to venue for patent infringement?
Well,
in
interestingly,
Washington State?
Amazon, I have it, I am told that Amazon has probably among the most numerous logistics facilities around the country. They don't advertise, but I think you'll find that Amazon has regular and established places of business all throughout the United States. But I also have reason to believe that the one place where Amazon.com does not have a logistics facility of any kind is, guess where?
Edie, Texas.
Yep, Marshall.
Probably a coincidence.
And I've heard tell of other companies who regret having set up shop on the wrong side of the street in Plano, Texas, because part of it's in the Eastern District and part of it's in another district. So,
Can I follow up on that?
certainly.
I think this raises a really good question about personal jurisdiction here, because Mr. Dabney made some comments earlier about forum shopping and patent cases, and that patent cases are a bit different. And I think what might be different is, and what maybe needs to be addressed, is personal jurisdiction in patent cases, not venue. So that the problem is not venue, but if there's a problem, and I'm not saying there is, if there's a problem, it's personal jurisdiction. And the way the personal jurisdiction statute, the way personal jurisdiction has been interpreted in patent cases, because it is easy to establish specific jurisdiction. So again, going back to civil procedure, in a typical patent infringement action, you have a patent owner who can sue just about anywhere, because all they have to prove is that the defendant has contacts, and those contacts are purposeful. Those contacts gave rise to the lawsuit, and that the exercise of jurisdiction is fair, right? Those are the basis for specific jurisdiction. So what are those contacts? You sell the accused product, right? So if you sell the accused product nationwide, you sell it anywhere, including the Eastern District of Texas. That's purposeful because you purposefully decided to sell there. And obviously the sale of that accused infringing product gave rise to the patent infringement action. That's the way the Federal Circuit has interpreted, in the Beverly Hills fan case, has interpreted the personal jurisdiction doctrine. It allows for personal jurisdiction to lie in virtually any district if you're selling nationwide. And if there's a problem to be addressed by the court, in my opinion, perhaps it's through personal jurisdiction. And coincidentally, or the Supreme Court has taken a case this term, the Bristol-Myers Squibb case, on personal jurisdiction, which may help to address this issue. So to me, it's not a venue problem. It's, if anything, a personal jurisdiction problem.
Interesting. Other questions? Sir?
So I have a question for Professor Anderson. Your argument is more along the line of policy and practical implications. Now, moving venue out of Eastern District of Texas would be putting it into the District of Delaware and the Northern District of California.
Yeah.
The District of Delaware, I think they have probably 4 active judges right now.
Rollins is going to retire.
That's
Yeah, so one argument that I really liked from a respondent was at the very end. He said, basically, if you take, you have one option. You can either leave venue as it is, or you can change it and say, no, it's just restricted to the place of incorporation. And those are really the two options. And he said Congress has a lot more options, and they can make a more precise cut about what we want to do with venue. I agree with that. So if we want to do that, that would be great. But I also think something needs to be done either by the courts or by Congress. I'm kind of agnostic about who does it. I'm just, if we have the rule that says you have to sue the defendant where they're incorporated, we'll have a ton more cases in Delaware. And that would probably overwhelm them. But in the long run, Delaware is a better place for patent policy to happen than East Texas.
Other questions? All right. Well, with that, I think one more. Yeah.
Professor LaBelle, you had talked about the implications this would have for other areas of law, like Hatch-Waxman, that was discussed briefly. Could you explain what that would be?
So in terms of Hatch-Waxman, there was the argument that was made, and Mr. Burgess might step in here too, is that under the America Invents Act, you cannot join multiple defendants in a single patent suit for various reasons. But there's an exception to that for Hatch-Waxman cases. But if venue was so limited, then you couldn't sue all these defendants. So in Hatch-Waxman cases, you have a branded pharmaceutical company suing all the generics who manufacture that drug, and it's convenient and efficient to sue them in one venue. But under the TC Heartland rule, that might not be possible because you can only sue each defendant where the defendant is incorporated. So that was one problem. But there have been other potential problems raised because I haven't looked at, there are hundreds of actually specialized venue statutes. So in 2011, when Congress amended 1391, there was the ALI's sort of preferred course of action would have been to sort of get rid of all the specialized venue statutes, but that would be a huge task, too difficult. So they took this sort of simpler path of defining residence and setting out other definitions that apply to all venue provisions. But questions have been raised, not necessarily in briefs, but people have talked about what impact might this have for admiralty cases, which actually Congress sort of carved out of 1390. But there are other specialized venue statutes too that use that definition of residence, and if it doesn't apply to 1400 maybe it doesn't apply to those other specialized venue statutes as well.
Great. Well, I think we've hit time, and I want to thank you for your attention. Could you please thank our panelists for giving us their time and thought. Please join us for a reception and further conversation. And thanks for having a long day. I appreciate that.
It's so important.
Yeah, the stakes are big.
Yeah, you as well.
When do you click
As I said it.
The 2012 term?
KSR, I said, if this is the biggest patent case since 1966 or whatever, that just shows how far the federal system is straight.
That's just a measure. Insurrection.
Yeah, like
take that and
although my daughter, I should call her. She was supposed to be on
It was well intended. They did.
So we're probably being videotaped.
You're talking about your webcast. We have a gift for you as well.
Oh, good.
I think it's a key. I don't even remember what it is.
I'm happy to.
I think it's gonna be a split.
Oh, it looks like a charger.
Oh, no, that's yours.
They try to make it useful.
He's always
So what do you teach?
Well, I'm mostly
Basically, we have different slides. He's for half of the time.
You getting
Just get a drink out here.
I feel like most
Leave whenever.
of their litigation now are towards ITC faster.
That has been successful.
It's not open, like, they don't cover civil.
So that's a good way to.
Well, I mean, US
It does look
ITC.
like the 740
So,
one time, but the
those are
9,
huge.
they're already saying is,
This one.
delayed.
So, I'd say Delaware has a long cases other than patent, because of keeping busy. They don't want on the patent.
Periods.
I
don't know how to do that.
So they'll.
Plan.
But I'd like to see,
Starting out.
then you said, create like Congress.
Are you concerned they should know as far as?
Yeah.
This can be our,
So,
because I thought I could go first and
So,
talk about.
there's some things, I think, one thing.
It's writing in our
Essentially,
this is the other thing.
I mean, that's
So,
a good heads up.
the way,
Yeah.
the cases there was one judge.
Wait,
You don't want to Texas.
I mean, that's all.
So, just making a rule that disallows that.
Definitely
I'm
by car.
assuming a judge. It's just.
I'm hoping for this now.
It's really just that one.
Would go along with it. That's, there are a lot of products.
Let me know if you guys need any help.
Yeah, I don't right now. Right now I have a lot of slides, but the idea is that they're the same thing for multiple periods. And just, they're doing animation to show 1970 and 2015.
I mean, you don't want to patent. Enforce it, you want to be in Texas.
As of now, there's not a whole lot of it.
So, until you get rid of the incentives for going to Texas, the incentives for Texas.
We can. I figured for this I'd focus on.
The trend to openness.
Oh, can we have those? Yep.
I'll be around.
Yeah.
Really? Oh, we have one more. But we have.
We can do, whether or not countries have a flexibility test, but no. I think we have to actually go carefully look at all the answers, because it's one thing if it's there's opening tests and there's closing
Can they
tests.
do like a Google spreadsheet like what we
We'll answer
got
the question the
and
same
just kind
way.
of see like where they're interested?
Or if it's like,
And then maybe we can.
there's an education thing that's only available for printed works and it's only available.
I'm good at logistics.
Then they have
That I
to
can
pass
help
some
with.
kind of.
That's telling
No, they would say subject to
maybe
amount.
those are more-
I think something needs to happen. If this is the thing.
Alyssa.
I'm not convinced this is one thing we have to do. It is fix the patent system. But I think this would go a long
Excellent.
way.
Well, it's important for different.
Destroying the monopoly.
So
Yes.
my sense of where we're going.
Well, let me know.
Yeah.
School, so the whole like
It would be nice if-
multiple people who think they have good ideas.
Here, so you file
Yeah,
this
that's
place of business.
wheelhouse.
Is.
So.
No, knock it off. That's the way
They
I
have
think.
something
This makes more
major,
sense.
like a facility, like you were saying about Amazon.
Openness gives you a dimension
That'd be great too. But just saying, anywhere you have personal jurisdiction, basically every.
That the exception doesn't specifically say you can do.
So that's a problem.
Right.
So
Choose and most likely to choose. The ability is something different to me. It's, does your courts, does your law require courts to do some kind of case by case? That to me is more of a defensive, like, say other courts can't do it. But I want to be able to point to, actually, everybody does it, you know? Like the number I would love to
Giving
have
us
in
stuff
that
that's like completely
of the
over our
civil
heads.
law,
You know, if they're looking at something that's very narrow,
how many
and maybe we've all read one case on it, like how
flexibility.
helpful can you really be?
And then we can also use that to kind of find it.
But
I have a bigger problem with courts.
I think that they're gonna have to understand as practitioners that the reading only goes so
So it's just
far.
it's more of that.
They might have to be like, look, this is what we're getting at. This is-
Completely.
Oh, obviously where you have
And I-
something where you can stand the flexibility.
I'm not sure there are things we can totally do to get rid of.
I think so too. I just hope that they understand when they're working with students
It's hard to do.
Yeah.
that they can
So
expect.
eliminating,
Well, not too much. I mean, I think it's just like, I think we've all worked with people that didn't quite understand where students were at. And so like, it's fine, you can bring us up to level like that, especially those of us that are new. You know, know everything that there is about the intricacies of patent when I'm
like
just now
to
taking
sue
patent law.
and.
But I mean, I think
And it's fine to tell me things, but you're gonna have to do that.
Parties liable. What
I mean,
if you're going to benefit there from that area, you should also
like this paper
be liable in essence for
really focusing on the four-factor test.
So
let's just hope I get
that they shouldn't hold even though they are gaining from the
Right.
practice that is being sold.
For rhetoric, they gave us a trademark case. I know it's different. For rhetoric, they gave us a trademark case, and all of us that are interested,
So
we were like,
basically, I've got a.
this isn't real. Like, we've already done the
We've got a
research.
meeting with Alan at 10. I've
It
got
was
a
on
meeting with
protectability, and then like, we weren't allowed to address
Should be allowed to
meeting,
say,
so
we
maybe
weren't allowed to
we'll
look
do
at the
it.
Fed circuit, we
that.
like do all of these things that you would definitely actually do. So like, none of us would ever want to use it as a writing sample, regardless of how good our writing is. It's bad law.
I mean,
in that sense.
Alan honestly
that
was
isn't
one of
really
the
taking
easier
advantage of-
ones to do.
Like-
I have a couple of
One thing I
questions,
learned
but
from
he
my
cited his stuff
All
well.
we're
He
doing is
did the
some
whole
people, like,
years.
offering to sell online.
So it's like, there are some people that if I sit down with them, it would be like long drawn out. This isn't gonna be one of those.
Okay, well, that's
Bring
good.
it
All
up.
right, let's play it by ear.
Do you agree with what you
We're not incorporated
your
there.
point of view?
And
My writing samples have it. I was tasked with taking this position.
Good
idea.
I didn't realize that.
Good idea.
Well,
We'll
venues
ask you about it.
pretty general for corporations in general, so everyone should be subject to personal jurisdiction wherever they are. So, I see that argument. I just think the impact it has on patent policy has been really bad.
Yeah, and I read the Wired article actually. Somebody pointed out to me and they talked about the policy, and I agree with that. I was just kind of like in my head trying to do the devil's advocate part of it.
It's a great. I mean, the argument goes both ways because that's why it basically hasn't happened. But I think for the argument that this is the Federal Circuit trying not to be different is true. The Federal Circuit has done just what they do in cases with corporations and antitrust and product liability. But I think this is an area where we need something specialized because patent cases are filed uniquely in Texas, and that's rare. And I think it's the only type of case that's like that. And so when you have that situation, I think there's things we can do that are unique to patent law that make it special.
Well, thanks again. I enjoyed listening in on that. It's very interesting. Like I said, I agree with the whole issue with Texas, and I read on it about how it has detrimental effects on services those corporations provide.